International Corporation et al. Versus Town of Forest Heights, Maryland et al. Mr. Liskow? Liskow.
Yes, sir.
Good to have you here, sir.
Thank you, sir. May it please the Court, James Liskow for the plaintiff appellants. This case concerns Maryland's speed monitoring statute, so speed camera tickets. But what's at issue in this appeal has nothing to do with the operation of the cameras themselves or whether that's appropriate. What's at issue here is more fundamental. The first issue I'd like to talk about is service of process. The first, last, and only time that a defendant is served with process here is by first-class mail. And our Supreme Court, since 1950, has shown, through numerous cases, has shown an increased concern with property rights and notice in regards to in rem proceedings.
The folks that are before us today are the ones who paid the $40 fine or whatever you want to call it. So the government says they had actual notice.
The process is still defective. And what the district court ruled below, and what's not up for appeal here, is that Maryland law does not find that preclusive to a lawsuit for a civil rights action. And that's what this is. This is a claim under 1983. Maryland law, the district court cited a Maryland Court of Appeals case, Baker versus Montgomery County, which was also a class action lawsuit dealing with speed camera citations. And what the Court of Appeals there said, they basically said the issues were different in that case. They said the issues were not raised because the plaintiff should have sued as taxpayers, that there was no standing. But the court also said, well, there's no res judicata bar, there's no preclusive effect of paying the citations because it's a $40 citation. People might pay these over and over and over again, but to bring this case in this manner has not been precluded by the underlying payment. There's no judgment against those folks that had paid the citations. They're
arguing notice, not res judicata.
I'm not arguing res judicata at all because it's not up for debate here. The appellee didn't appeal it, and the district court found in the appellant's favor on the issue of preclusion. So there is no res judicata part of it. What we're arguing about is whether or not first-class mail alone, by itself, without posting, publication, or any attempts at personal service is a constitutional manner in which to serve a lawsuit. And it's not just for speed camera tickets, although that's where the Maryland statute has it. But what the appellants would have this court do is basically rubber stamp that alone as being service of process for a civil action when you're not talking about property.
You mean that's what the appellees would have?
Excuse me, sir. Yes. That's what the appellee's position would be. You stick the complaint in an envelope and you mail it to the defendant. You never have a return. And you just say, well, I mailed it. I didn't post it. I didn't publish it. I didn't do anything else. I just mailed a copy of the complaint, or in this case the civil citation, to the defendant. Therefore, give me a judgment, and here's his last known address. And what we're talking about here is a money judgment. We're not talking about an administrative proceeding like the MVA coming in and saying you didn't register your vehicle, you have points on your license. We're not talking about that kind of proceeding. We're talking about two parties who have nothing to do with each other. The appellees below are municipalities. The appellants below are folks that just happen to drive through those municipalities and received a citation in the mail. And that
it's called a citation. You were calling it a complaint?
It's a civil penalty. So it's not...
Stop on the front page of it or the front top of it, it says citation.
Yes, sir. It says it's a civil penalty. And if I'm using the terms interchangeably, it says it's a civil action, and it says that there's no criminal infraction for it, So what I think the court should
What is it, 2 pages?
it's one page and then it's on the back.
Well, that's what I mean.
Yeah,
2 pages.
it's one piece of paper though, but yes, it's 2 pages. And what we're dealing
Gives
with,
you a lot of information.
it does, sir. But the information provided, other than the signature, which I haven't addressed yet, isn't the issue. The issue is that the appellees have attempted service by means of first-class mail, threatened a judgment, which they would take by means of first-class mail alone. No other service attempt is made. There's no other proceeding where that's allowed or done. Any other civil action, if I came to any court in Maryland or in the federal system, I said, well, I mailed a copy of the civil action to the defendant, give me my judgment, he hasn't answered, that wouldn't fly anywhere.
What kind of a presumption is there in the law that something that's placed in the mail, in first-class mail, gets where it's supposed to go?
There's a strong presumption that it gets where it's supposed to go, but what we're talking about here is service of process. What we're talking about here is a little more important.
Probably a lot of people in the penitentiary have criminal offenses for involving mailings that were presumed to have been received.
Certainly.
Mail fraud cases and the like.
Certainly, but what we're talking about here is the initiation of a lawsuit. That's a little more important than service of a notice of a proceeding. What we're talking about here is the initiation of a lawsuit, allowing the appellee to take a default, and then allowing the appellee to take that default, take that judgment, and execute upon it. And we know that that's what they can do because the statute itself refers to owners of the motor vehicle. It says if the vehicle goes past the camera, we'll issue the owner citation.
Now, they use these cameras, in like school zones?
Yes, sir, and work zones.
Work zones? Mm-hmm. When they're working on the highway?
Yes.
For the safety of the workers?
Yeah, and
it's a laudable goal in both instances that you agree with all that, don't you?
I certainly do.
We want people to slow down going through the school zone. We need people to slow down going through the work zone.
We certainly do, but what we're talking about here is the initiation of a lawsuit. The facts haven't been proven yet. What we're allowing the appellees to do is to put an envelope in the mail without doing anything else and to take a judgment. They haven't proved anything at that point.
Judge, Mott's cited Matthews versus Eldridge. The 1976 case has kind of some balancing factors in it. And then went through them and analyzed them.
He certainly did. I don't think that's the appropriate way to go through it. Because I think Mullane versus Central...
You think that's bad law, that old case, like the Matthews versus Eldridge, is no longer the law?
That has nothing to do with the service of process issue. And I think the service of process has followed a different line of cases, starting with Mullane in 1950, which said that basically notice, to meet due process, notice shall be reasonably calculated under all the circumstances to apprise the interested party of their rights. And that's what Mullane Central Holding is. Mullane dealt with a property action, dealt with bank accounts, and the only notice provided to the account holders that there was a judicial settlement was publication. The court says, well, that's not exactly fair. That doesn't meet due process. You have to have notice reasonably calculated to apprise the parties of their rights. So why don't you at least mail them a copy of this? We're still talking about a property action. The court doesn't reduce what's required for an in personam action. It just brings in rem actions into the fold of requiring actual due process and calls publication a fiction. That's what that case says. So what we have after Mullane is basically in rem actions being treated more like in personam actions, but it doesn't reduce what in personam actions are. And none of even the in rem cases that either of the party cites states mailing alone is sufficient even for an in rem action. And the reason we have a difference between what traditionally were called in rem actions and what traditionally were called in personam actions, and we still do, is because of exactly what Mullane is talking about. Under all of the circumstances. Under the circumstances, a property owner has the right to enjoy property, but they also have the responsibility to take care of that property. And that means that if something's posted on the door that says you haven't paid your mortgage, the bank's going to take it. You have an obligation to look for that notice. You can't just ignore your own real property or personal property. Same thing with a forfeiture.
How about our decision in this Plummer versus State of Maryland case involving revocation of a driver's license?
In that case, you have an administrative action, so the defendant in that case already had a relationship with the administrative body, asked the state for the privilege to operate a motor vehicle, already had that relationship with the body, with the administrative body. It's no different than if a doctor was getting their license revoked. There just happens to be more driver's licenses. That's the central difference there. The defendant or I guess respondent in the Plummer case already had that relationship, already had a duty to respond to the MVA. Here we have a municipality or two municipalities, and people have nothing to do with it. We're not talking about property within the municipality, and there's no taxes paid on them.
Though with this kind of the balancing test that Judge Motz used in the district court, I'm guessing most people would think that their loss of their driver's license or their loss of their medical license, which they received the notice by mail, would be far more important to them than receiving a notice for a $40 citation here.
What I think the Mullane case is telling us is that what we look at is the relationship between the party and the action or the underlying property. You already have a duty to, if you're a physician, you already have a duty to maintain your license. If you own property, you already have a duty to maintain that property and to know what's going on with it. You already have a relationship with the bank that's taking it in most cases. You already have a relationship in a forfeiture action in many cases, but you have a relationship to the collateral or the property in forfeiture action. You have to know where it is and know what the status of it is. But here you just have people driving in front of a speed camera. In a forfeiture, we don't look at, in a foreclosure, we wouldn't look at what the property itself is. We wouldn't say, well, that house is really nice. That's a $20 million mansion. This fellow should get more due process than this guy with a $20,000 double wide. We don't look at it like that. And I think the Supreme Court precedent is consistent with that we look at what the relationship is between the person and the action, the defendant and the action. Here, because as a property owner, you know what's going on. You have an obligation to know what's going on with your property, and you have to follow up. As a defendant in an in personam action, there's nobody but you. If you don't actually receive constitutional notice, what are you supposed to do? You don't know about it. But as a property owner, you should know about it. You should know the bank's going to foreclose because you haven't paid the mortgage. You should know you're about to be evicted because you haven't paid your rent. You should know what's posted at the front door, what's mailed to that property because you own it. But here you're talking about a defendant in a civil action. If this court allows the appellee to get what they want here, what you're essentially going to rubber stamp is any civil action being sent by first-class mail from a constitutional standpoint. The state of Maryland, Commonwealth of Virginia, any other state would be able to reduce their statutory requirements for service process to just that. No return of service. You'd never get a return. All you'd have is first-class mail. Maybe you'd have an affidavit of, I mailed it. That would be it. Because that's all they don't even have that, but that's all they could ever have is an affidavit of, I mailed it. And my clients, the parties pay the citations. It doesn't have anything to do with what this court should decide, because it didn't have anything to do with the district court's decision, because there's no preclusive effect. They pay the citation just to get rid of it in most cases, and not going to look at it from a constitutional basis. That's what the district court held. That's not up for appeal. What's up for appeal is whether or not first-class mail and first-class mail alone satisfies due process. If we look at page 316 of the Mullane case, Mr. Justice Jackson gives us a hint as to how he's thinking when he writes that opinion. He says, the ways an owner with tangible property are such that he usually arranges means to learn of a direct attack upon his possessory or proprietary rights. So he's saying the same thing I am. He's saying it a little nicer than I am. But the truth of the matter is, what's at issue in the Mullane case, which is the leading case, and the other case that followed, I just don't have that much time to talk about them. What's important is the debtor or the defendant's connection to the underlying action. And we don't look at, well, it's a $40 citation. We look at, this is an in personam action. I'll try to address the second point in my rebuttal. Thank you very much.
Thank you, Mr. Lisco. Mr. Karpinski?
Thank you, Your Honor. Kevin Karpinski on behalf of the Appalese, Town of Riverdale Park, and the Town of Forest Heights. Let me start my argument, Your Honors, with correcting a statement made by my colleague. He indicated that this was a civil action resulting in a money judgment, and that is simply not a correct statement under the statute. There can never be a money judgment ever entered in this as it relates to this particular statute. And specifically, I'm referring to 21809G, which says that if a person liable under this section does not pay the civil penalty or contest the violation, the administration may refuse to register or re-register the motor vehicle cited for the violation, or may suspend the registration of the motor vehicle cited for the violation. There is never an occasion where a judgment is entered against the alleged violator. Runs to the vehicle. Runs to the vehicle, Your Honor, and it's important to put the violators in three categories.
It's not a judgment that clogs title to real estate or ends up on somebody's credit rating or something of that nature.
Absolutely not. And in fact, Your Honor, there's not even a late fee associated with this. If I re-registered my vehicle today and I went out and got a speed camera ticket tomorrow, then the only recourse would be 2 years from now when I have to re-register my vehicle in the state of Maryland. They would say, Mr. Karpinski, your vehicle has been flagged for a speed camera ticket you got 2 years ago, and you need to get that resolved before we'll go ahead and handle your registration. There's no late fee involved. There's no penalty involved. It's $40 even if you don't pay it at any time. So really there are three categories of potential parties here. We have those that received the notice of citation and they paid it. They got it in the mail, and I've gotten them. And it's either myself or my wife or my kids or someone is, it's right there, date, time, vehicle, location, and I get it, and I get it within 2 weeks, and I go, well, either I was exceeding the speed limit more than 12 miles an hour, or someone in my family was, and I just pay it. So I actually got that citation. The second group...
Is that where all these people are?
No. The second group is the group that got the citation, said, you know what, this is just flat out wrong. I wasn't speeding, or I wasn't the operator, or my vehicle had been stolen, or as permitted under the statutory scheme, I can present any defense I want in district court to that action. And I go to district court, and I go ahead and I defend it and say, for whatever reason, I shouldn't have to pay this $40. And that's the second category of people. And those people got the citation, obviously, as well, because they availed themselves of due process. Those people are not before us, Your Honor, because although there were some that fell within that category, the district court found that they were barred by res judicata, and appellants failed to appeal that portion of Judge Motz's order. The third group would be those who contend that they never received the notice of citation. And I would note that none of the plaintiffs below or appellants here have asserted they did not receive the citation. But again, the only penalty, for lack of a better term, is if you claim you didn't get the citation, would be that you need to get it resolved before your next registration period. So the deprivation of a property right is very, very minimal on the alleged violator or the owner of the vehicle.
So you send it to another state if they're out of state?
Well, quite frankly, Your Honor, in all candor, we have very little recourse against out-of-state motorists because the only recourse we have is regarding registration of the motor vehicle. So if it's sent to an out-of-state motorist that has committed a violation, it's sent. If they pay it, they pay it. If they don't pay it, there's really not much that can be done about it because it's not a motor vehicle.
That's the end of it. They don't pay it.
What's that?
The out-of-state driver doesn't pay it. That's the end of it.
That's the end of it. We don't have any authority over the vehicle or the registration of the vehicle.
So you have an equal protection problem.
Well, no, not necessarily. Well, you know.
You treat your residents worse than you do people out of state.
Well, that was not raised, Your Honor. But
I know it wasn't, but that's in fact what you're doing.
Well, it's just that we just because of it's more of an administrative proceeding. It's not a civil lawsuit. It's administrative, much like an MVA proceeding. There's only so much authority that the jurisdiction has, and because of the statutory scheme, that it is really tied to registration of the vehicle, there is not much recourse for out of state. I guess in theory, you could report it to a collection agency. You could do something of that nature.
How much money or much revenue y'all generating on this program?
I don't know the exact numbers, Your Honor, but it is a situation where it does generate a substantial amount of money, but that money has to be used as an offset. Most of it goes back to the state of Maryland for public safety programs. The other money has to be earmarked for public safety issues within the various jurisdictions. So,
are there other towns in Maryland that are doing this other than just these two?
Absolutely.
So it's happening everywhere, all over the state?
It's happening all over the state, yes, Your Honor. Montgomery County was...
Is it only happening in these work zones and school zones? What if I'm driving up I-95? They take pictures of me?
If you're in a construction zone, what will happen is it will say that it is a photo-enforced construction area, and if you are going more than 12 miles an hour over what is the speed limit in that construction zone, yes, you can get a citation for that.
On any highway in the state?
Correct. But the statute requires that there has to be posting. In other words, that you're actually entering into an area that is subject to photo enforcement.
They just, in this instance, they just sued your two clients.
That's correct.
That's how they.
That's correct. And there are other counties and there are other municipalities.
The town of Forest Heights, all their stuff goes to Philadelphia.
Because, well,
it's not in Philadelphia.
No, but the reason why is because depending upon the jurisdiction, they use different vendors that assist with the operation of the speed camera systems and the equipment. So you may have...
But you're a collection agent up in Philadelphia.
Right. And that part of the contract is who actually handles some of the billing. So Forest Heights uses a contractor that has someone in Philadelphia. I have another client, Gaithersburg or Chevy Chase Village, that uses ACS out of New York. But then it's all really tied to the administrative services that are provided by the vendor who's providing the equipment.
Under the Maryland statute, can the state itself put these camera areas, make that applicable on a particular section of the state highway, or does the locality in which the highway is located have to adopt an ordinance to make it applicable?
The locality is, Your Honor. So what happens here is if you're in a school zone or you're in a construction area, those are really where the speed monitoring systems are located. That's where they have to be posted. There's a posting period where you have to give 30 days of a warning period where you just give out warning citations, and then you can continue to do that. But generally, the public safety here, the interest is it does, whether you like these cameras or not, it makes people slow down. And makes them slow down in important areas where our kids are going to school and where we got workers sitting out on I-95 and 495 doing work. So, there's an important safety component to having these cameras operate.
Or, say, just a resident of the District of Columbia, you drove through one of these towns and you got one of these citations. You didn't pay it. And then you drive out in Maryland somewhere where and you're pulled over for a defective tail light, and they're running your information through the computer while the trooper's sitting there with you. Will this show up on that?
No, because with these citations, it doesn't affect your insurance, doesn't affect your points, and it cannot affect your driving privileges under your driver's license. So no, this would not show up as something that's how minimal the burden is on the owner of the vehicle. It does not even affect them in that regard. And so, no, you got pulled over in a different jurisdiction, unlike if you failed to show up in traffic court for a moving violation where they could say that you failed to appear. That's not the case with a speed monitoring citation. It would have no effect or no bearing on that particular
I want
stop.
to follow up on Judge Agee's question. You did say that if you don't pay this, repercussion, one of them at least, and the main one is, as you explained it, is that when you go to re-register your car, it will flag that you owe $40, so now you owe the reissuance or re-registration fee plus that, correct? Plus the $40 you didn't pay. Is that right?
You have to resolve the $40 citation, correct?
That means that you are informing the Division of Motor Vehicles in your state that they have that citation. It has to be, right? Because they're the ones who, the Division of Motor Vehicles are the ones who administer registration of cars. So that information has to be connected to them to know that you owe $40, right?
Correct, to the Maryland Department of Motor Vehicles.
Okay, the state, right?
Right.
Okay, that's how it is in Virginia, right?
Right.
So if you come home, and this what could happen here, these little places like you're talking about where your client, you come home, you have 12 of these citations. You say, I'm not paying any of them. So that's 12 times 40. At some point, couldn't the state of Maryland say, we're going to administratively take your license? Because you have 12 of these citations, and there's an indication that you or someone in your car is speeding.
They could administratively suspend the registration of the vehicle. They could not affect your driving license privileges because the statute does not, because we don't know who the operator would be. You could certainly suspend the registration for the vehicle.
That car.
Yeah.
But you would not prohibit you at all from driving a car.
Correct. That's correct. That's the way the statute is set up. So, Your Honor, that is, Judge Motz did do a balancing test. But before we get to that balancing test, I mean, fundamentally, it starts with the Milan case back in 1950. And basically, that case has said that notice needs to be reasonably calculated to provide notice to affected individuals. And if that's the case, then due process is satisfied. And certainly, the only real defendant, the real plaintiffs we have in this case are the ones who paid the citation. So one, we knew they actually got it. And one of the cases that we cited was Moore versus City of Gaithersburg.
So all these plaintiffs are in Category 1.
Correct. They have it. They got it.
But you told me a while ago they weren't.
Well, the only ones that are here on appeal.
That's what I thought.
Yeah, because
That's what I'm talking about.
Yeah,
The plaintiffs.
well, there are two sets of plaintiffs.
If they aren't, but the second category was thrown out.
Correct. Yes. So the only ones here, Your Honor, are those that received it and paid it. First category. Yes, sir.
Got them and paid it.
And Moore versus City of Gaithersburg, this court said something to the effect of you cannot complain of due process if you did not avail yourself of the process in the first place. And in this particular instance, it's clear they received it. They elected not to go through the district court proceeding, which they could have had a full evidentiary hearing. They could have had a de novo hearing in our circuit court if they wished to do so. They could have appealed that to our Court of Special Appeals. They could have filed a petition for writ of certiorari to our Court of Appeals. They could have filed a petition for writ of certiorari to the Supreme Court if they were going to raise a constitutional issue. So all that due process was available to individuals who unquestionably received the citations in the first place. And I think the cases that we've cited in our brief that followed Mullane with Tulsa Professional Collectional Services, Mennonite Board of Missions, Green versus Lindsay, they stand for really two important propositions. They stand for the proposition that in 1950, when Mullane was decided, the court did away with this analysis that we're going to worry about whether it's in persona, in rem, quasi in rem. The test is whatever action it is whether the notice is reasonably calculated to provide actual notice.
Didn't you have a subgroup in the class that's before us now? I don't think the plaintiffs made this argument. Maybe they have, but I don't think so. Where you did pay this $40 citation, but the only reason you paid it was your registration came up and there's this $40 citation on it, and that doesn't necessarily mean that you got the notice in the mail the 2 years earlier. You just decided it's easier for me to pay the $40 now than to fight it. Wouldn't there be a subgroup that could be within this class that wouldn't necessarily have gotten actual notice?
Yes, and I think there are 2 points there, Your Honor. First is there's not a group that is before this court that falls in that category, and I believe that person would be able to try and seek recourse through the district court to say, look, I never got the notice, and we're asking the court to exercise its authority to revisionary authority to consider it if the person ultimately decided to do that. And the second point out of Green and the other cases we've cited is that the Supreme Court has repeatedly said that regular mail is a reliable, less expensive way to go ahead and provide actual notice to people that are affected. And when you think about it in this case and you balance the fact that you're talking about $40 and you're talking about something that does not suspend someone's driving privileges, if you had to personally serve that person or you had to rely upon certified mail, that would be a tremendous burden upon any governmental agency to have to go ahead and do that. It just would be an onerous task, one, because personal service is tremendously expensive, and two, quite frankly, a lot of people don't pick up their certified mail. So regular mail is really the most reasonable, well-calculated way for people to actually receive what is in the mail. And of course, the statute requires that for residents within the state of Maryland, they get it within 2 weeks. Out-of-state residents get it within 30 days. There's not a tremendous amount of lag time between one and the other. The other issue that was raised on appeal relates to this electronic signature. And I would just like to briefly discuss that issue.
Before you do that, let me ask you this. How many states have the similar statutes?
How many states have similar statutes?
Yeah, how many states are out doing this?
You know, Your Honor, I don't know. I don't know the answer to that question.
Are we going to get them from everybody else in the circuit, or you get
well,
you just the lead dog in these other 4 cases?
I hope you don't get any more, but I don't know how many states actually do use them. Certainly, Maryland started with one county, and they've expanded it throughout the entire state to be able to be used. The appellants have argued that an electronic signature is not appropriate under the circumstances, and I would just raise 2 points. As the district court indicated in its opinion, Maryland has adopted the Electronic Transaction Act, which is in the commercial law article at 21-106, which basically provides that an electronic signature has the same force and effect as a handwritten signature. Judge King had raised the Matthews versus Eldridge analysis, which has been used ever since that decision for a due process analysis. And when you apply those factors, it's clear that an electronic signature is entirely appropriate and meets the minimum standards of due process. The first prong is whether the private interest that will be affected by the official action, and in this particular case, we're talking about a civil penalty of $40 with no late fee, doesn't affect your insurance, doesn't affect your driving license status, and there are no points. On the other hand, the countervailing benefit from the government's perspective is health and safety, making our motorists slow down around areas where we have kids and we have construction workers and we have other individuals that may be vulnerable. The risk of an erroneous deprivation of a right, well, that clearly weighs in favor of the appellees, too. There is no significant deprivation for the reasons I've already stated, and this notice is sent out within 2 weeks. It provides you the date, time, speed, and location of the alleged violation. Tells you can pay it or you can contest it. As Your Honor pointed out, there's a very lengthy description on the second page, the back side of it, that tells you exactly what it is and what it means and how it can be challenged. And then the third is the administrative burden of having this handwritten signature as opposed to an electronic signature, and it would be a significant burden. I don't know the exact numbers, Your Honor, but there are a lot of these citations that get issued throughout the state. To require a person to handwrite that rather than review it on a computer, approve it, and have an electronic signature would be a tremendous burden, particularly when a lot of these citations are not necessarily mailed out from the local jurisdiction itself. I see that my time is up. Unless Your Honors have any questions, I will submit.
Thank you very much, sir.
Thank you.
We appreciate it. Mr. Lischko?
I find sort of interesting some of counsel's arguments about what we're talking about, whether it's a money judgment or something else. I think the statute makes it clear that it's not just a money that it's not just an administrative citation to the car. All three of the portions of the statute that talk about what the MVA can do say that they may, not that they shall, and nothing in the statute itself says this is all we're talking about. These are the only potential penalties. Nothing says that. In fact, the statute itself says that if the owner receives a citation and the driver wasn't driving the vehicle, the owner can mail in an affidavit and say, well, here's the driver, and then a citation can issue against the driver. So the appellee's reading of the statute basically reads that part of it out of the statute because there's no sanction against the driver who's getting the citation. Basically, they're getting mail that they need not respond to, and if they do, oh well. But if they don't, and they go to court, there's no sanction. That reading doesn't make any sense. I think what we're clearly dealing with is a money judgment. You have non-resident drivers receiving these citations. I think the court has to read this statute to give it meaning, to say what did the legislature mean, what did the Maryland General Assembly mean, and I think it's clear that
where do you read in that you get it results in a judgment against anybody?
It's being filed in Maryland's district court, which is a trial court, and it's being adjudicated there, and the court is entering something that says $40. If it looks like a duck and quacks like a duck, it's probably a duck. We're dealing with a judgment. We're dealing with a money judgment. There's nothing in the statute that precludes any of these jurisdictions from seeking to enforce their judgments through the full faith and credit of the United States, of the various states, and say, well, this is a Maryland judgment. I'd like to enter it as against Mr. So-and-so who lives out of state. Oh, and we have a Maryland resident who is driving. I'd like to garnish his wages. I'd like to lien his house. I'd like to levy upon property. There's nothing in the statute that says that. What we have is a penalty of $40 issuing. And Maryland statutory law dealing with collections.
Let me make sure. Are you saying that all these indicia of a traditional money judgment, application against real estate, garnishment of wages, that the locality here would have the authority to do that?
I think so. I don't see why not. They have the district court, which is not their court. That's the Maryland's courts, entering a judgment in their favor, saying you have to pay the locality $40. I don't see how that could not be a judgment. I don't see how that could not be collected upon. The statute says you may be able to do this, you may be able to do that, but it doesn't preclude any sort of collection action. And in fact, you're going to have a piece of paper signed by a judge that says $40 against the defendant. That sounds like a judgment to me from any court I've ever heard of. I don't see how that's not a judgment. I think one area.
So you're saying all of these citations go before a judge?
Yeah.
All of them?
If they're contested, they would go before a judge. If they're paid, they don't end up there, but they would eventually be ruled upon by a judge, and the judge would sign the order, the final order saying $40. So that's a money judgment. So what you're dealing with is mailing out process for a money judgment using first-class mail. None of the cases cited say that first-class mail by and of itself,
Well, if you don't get notice, then it won't go before a judge.
If you don't get notice, it will go before a judge.
No, it won't, because it'll just automatically just go on as a citation that you owe it.
That's not how you get a default. The judge will sign the order
and
saying.
You're saying then all of them go before a judge. That's why I asked you.
Well, if you pay it, it wouldn't go before a judge. That was what I was trying to express.
Or if you don't pay it, you're saying it goes before a judge.
Yeah, and the judge will sign sign off on it.
What provision is that?
I mean, that, in the statute itself?
Yeah, what provision says that?
The whole statute says it goes to the district court, so it doesn't say it goes to the district court judge, but it says it goes to the district court.
Or default judgment. Where does it say that?
You know, it may.
It doesn't, does it?
No.
You're doing a whole lot of reading into it, isn't it? Aren't you?
But I mean, that's generally how judgments are entered, not by the clerk and not by the plaintiff. The plaintiff doesn't enter the judgment.
That provision is only for people who contested. You get due process right to raise your question. I don't see anything where it says that if you don't respond at all, it goes before a judge for a default judgment. It didn't say that.
That would just be my general understanding as to how courts work. I see I'm out of time, Your Honor.
Judge King is the lead judge, so if he wants to give
answer all the questions, Judge Gregory.
I'll do my best.
If you don't mind, if he can have his 30 seconds to wind up since I took your 30 seconds.
I think it's a money judgment. I think it's pretty obvious it's money judgment. And your mailing out process, I didn't touch on the affidavit problem, but that is what secures the judgment. And that's not testimony. You wouldn't send the affiant to jail. You wouldn't allow him to perjure himself with an e-signature. So it says it's an affidavit. It's not. Thank you very much.
Thank you very much, sir. We'll come down and recounsel and take a quick break.
This honorable court takes a brief recess.